Good morning. In the previous session, we have seen what do you mean by intellectual property and intellectual property rights. Then, what are the basic principles and what are the laws in India, how they are, when they are constituted, and then types of IPR. So, in that we have completed or we have discussed about copyrights and related rights. And in the industry property, we will see we have seen patents, and today we are going to continue with which parts or which are not patentable. So those points will be discussed. So we have seen these rights, types of rights, ownership, author, then related to rights, patents, and what can be patented and what are the features or what are the characteristics of a product or process which can be patented. Those things we have seen. Conditions for patent and grant of patent, and couple of examples from certificate of patents. Now, today we will see the invention which are not falls under patentable or which cannot be patentable. So, an invention which is frivolous or disputable or like trivial, it may be present everywhere or general, or which claims anything obviously contrary to the well established natural laws. So, it may be already well established and you are uh, stating some contrary statement related to that, or something which is in general or which is already present, so that cannot be patented. For example, machine giving more than 100% performance. So this is known that most in some cases, power plants, the plant load factor is more than 100%, so that cannot be patented. Perpetual motion machine or Newton's laws of gravitation, everyone knows that there is gravitation on the earth, so that cannot be patented as a patent. Then a machine whose primary or intended use or a commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant, or health, or to the environment, anything. So such things also can't be patented. For example, gambling machine or a device for housebreaking or biological warfare. We have seen in the last few years there were talks about biological war or virus wars like that due to corona, and so those can't be patented. Or terminator gene technology, embryonic stem cell. So these all things cannot be patented, or these inventions cannot be patented. Again, what things are not patentable? Mere discovery of a scientific principle. If you have uh, discovered some principle or formulated some abstract theory or discovered of any living thing or non-living substance occurring in nature which is already there, so such discovery or formulation cannot be patented. Now discovery adds to the human knowledge by disclosing something, whereas invention adds to human knowledge by suggesting an action. So you can see a discovery adds to the human knowledge by disclosing something which is not seen earlier, whereas invention adds to the human knowledge by suggesting an action resulting in new product or new process. So that is the invention. So which results in a new product, useful product to the society or human being, living thing or non-living thing, or it may be a process, new process which does value addition to that particular process or to the society. Those things can be patented. Now Archimedes principle, superconducting phenomenon are not patentable. However, if you develop an apparatus or develop an method for technological applications, those may be patentable. If you have written some algorithm to develop some apparatus for the betterment of humankind, those things can be patented. Again, which things are not patentable? That is mere discovery of a new form of known substance. Already some chemical substances are there and you have formed new form of the same substance, then it does not result in any enhancement of the efficacy of the substance, so that it cannot be patented. Again, a new property or new use for a for a known substance. If you use some substance for the new use, then also that is not a patentable invention. It is an invention but not patentable. Again, use of a non-process machine apparatus, unless such non-process results in new product or employs at least one new reactant, then it cannot be protected. If you from this invention, if you develop some new product or employs a new reactant, then you can do the patenting. Otherwise, it cannot be patentable. A substance obtained by mere admixture, resulting only in the aggregation of the properties of the components. Therefore, a process for producing such substance is also not patentable. So for example, paracetamol, which contains antipyretic plus brufen, that is analgesic, equal to a drug. So a soft is also not patentable. A soft drink that is only mixture of sugar and some colorants in water, whereas a mixture resulting in synergetic properties of mixture of ingredients may be patentable. So if you just add sugar and some colorants, then it is not patentable. If you add some synergic properties of mixture which of ingredients, that may be patentable. For example, soap, detergent, lubricant, these all things can be patented. Again, just doing some manipulations or arranging or rearranging or duplicating some known devices, and each functioning independently of one another in a known way, is also not patentable. For example, a bucket fitted with a torch, an umbrella with fan, a cap with fan, or a clock with radio, or floor mill with saving. So these cannot be patentable. Then in case of agriculture or horticulture, cultivation of an algae or producing a new form of known plant. So already existing plants are there and you have just modified or hybridized it, so that cannot be patentable. Preparation of an improved soil is also not patentable. But if you develop an equipment which is useful in the farming or which is useful in the agriculture sector or horticulture sector, that product or that equipment or that apparatus can be patentable. That can you can patent it. So we have seen some equipments like sugar cutting machine or crop cutting machines. So such things can be patented, such products. Then related to the plant and animals in whole or any part thereof other than microorganisms, but including seeds, varieties and species, and essentially biological process for production or propagation of plants and animals is also not patentable. Clones and new variants of plants also non not patentable. So process of for production of plants or animals, natural phenomenon such as crossing or selection. So those things also not falls under or not comes under patenting. So all these things are not patentable. Then related to the algorithms or mathematics. So a mathematical method or a business method or an algorithm or a computer program, these also cannot be patented. Actually, these are the outcomes of a mental process and only do not involve industrial process or thought. So or a business method or model, or you have written some algorithm to solve some problem, or you have developed some program. So those things cannot be patented. These things can be put under copyright. Now, A computer program claimed by itself or as a record on a carrier can be copyrighted. Now, a literary, dramatic, musical, or artistic work, or any other aesthetic creation, including cinematographic work and television productions. So, these all cannot be patentable, but these subject matters fall under copyright protection. So, you can copyright your work. It may be related to your literary or drama, or you have composed some music, or you have done some cinematographic film or work, or movies, music. So all those things you can protect under copyright protection, but you cannot patent it. A mere scheme or rule or method of performing mental act or method of playing game. Say scheme of learning a language, method for solving a crossword puzzle, method of learning a language, or method of teaching or learning. These cannot be patentable. So we know, as a teacher or as a faculty mentor, faculty uses different innovative teaching learning tools, but those tools or those techniques cannot be patented. Novel apparatus for playing game or carrying out scheme is patentable. If you develop some apparatus or equipment which uh, performs the playing of game operation, then that can be patentable, or which is useful in particular aspect in application, then that can be patentable. Again, no, again, what things are not patentable? Presentation of information. So, for example, you are giving some lectures at public in a conference or in a workshop, then that lecture or that presentation cannot be patented. Any manner or method of expressing information, whether by spoken words, visual displays, symbols, diagrams, or information recorded on a carrier. So, if you have developed some presentation and you have circulated it, so that cannot be patented. Or if you have talked on some topic of your research, then that spoken words can't be patented, or some symbols, diagrams, or information on some document. Topography of integrated circuits, an invention which in effect is the traditional knowledge or an aggregation of duplication of known properties or traditional known component or components. So if you have done some modification in the integrated circuits, that cannot be patented. If you have developed or designed some new circuit, then for some application that can be patented. Again, traditional knowledge which is already in the public domain through some books or through general knowledge, and that cannot be patented. However, any value addition using traditional knowledge leading to a new process or product, possessing novelty, inventive step, and industrial applicability can be patentable. So this is important. Using traditional knowledge leading to a new process or product. So you are developing some new process, innovative process or product which is not existing earlier, which possesses novelty, means it is having some new thing or new process or new product which helps in the industrial applicability, or it is applicable to the industry or to the society. Such process or product can be patented. Okay. So only traditional knowledge is not sufficient. You can use the traditional knowledge to develop some process or product. Then inventions related to atomic energy is also not patentable. It can be patented, and what are not included or what are the excluded things from the patenting. Now the next type under intellectual property rights is industrial designs. So first we will see what do you mean by design. So design means only the features of shape, configuration, pattern, ornament or composition of lines, colors applied to any article, whether it may be in two-dimensional, three-dimensional, or it is in both forms by any industrial process or means, whether it may be developed or created manually or automatically or mechanically or using some chemical formulas or separate or combined, and which in the finished article appeal to and are judged solely by the eyes. So such things we call it as design. So we'll repeat or we'll see again. It is features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article. Article here does not mean a document. It is means some product, whether it may be in the form of two dimension or three dimension, or it may be in the combined form 2D and 3D both by any industrial process or means. It is product applied to 2D 3D by industrial process. It may be done manually, mechanically, chemically, or some combination is used, and which in the finished article or at the end appeal to and judged, or it can be seen by the eye. So such things we call it as design. Now the laws governing to this industrial designs are existing in India, and such one law is Designs Act Law of 2000. So and the Designs Rules of 2001. So these two governing designs are there: Design Act of 2000 and Design Rules of 2001. In India, designs are defined as follows. A design refers to the features of shape, configuration, pattern, ornamentation, or composition of lines or colors applied to any article in two or three dimensional or both forms. And this is the official definition. Just we have seen in detail, but here it refers to the features of shape, configuration, pattern, ornamentation, or composition of lines or colors applied to any article in two or three dimensional, or it may be combining of both forms. And this is uh, taken from the Design Office Kolkata from the guidelines for registration. And in India, designs any industrial design is valid for 10 years. Once you register any industrial design, then it is valid for maximum of 10 years. And afterwards, you can renew it for further 5 years. Now, the right of priority for previous fillings of designs overseas requires filling in India within 6 months of an overseas filling. So, the right of priority for previous fillings of designs overseas outside India requires filling in India within the 6 months after filling the overseas. If you have filled some industrial design overseas, then within the 6 months you need to fill it within India also. The distinction between what exactly may be protected by each and the relative levels of protection are complex. Experts' advice is needed to choose which is appropriate. So, to identify or to distinguish between what is exactly protected and what what are the levels of protection, for that purpose, one need to take the advice from the experts. Now, mostly the common type in industrial designs is registered designs. that is covering the appearance, it is shape or pattern of a product or its packaging, as well as typefaces and graphics. But to be registered in the UK, a design must be distinctive and novel. Yes, that is applicable everywhere. It should not remind an informed person of an existing design, as well as meeting other detailed criteria. Then there are costs involved in obtaining registered design rights. So compared with relying on unregistered design rights, which are free actually, but if you want to do the registered design rights, then you need to uh, cater some cost. So it is similar to the IPR. Like IPR can be treated in the same way as the patents, and rights owners exploiting their IP through licensing, and it provides a good level of protection. So if you protect through the IP, then it provides a good level of protection for your industrial design. And in India, it is 10 years plus 5 years, but in UK, it is last or this registered design right lasts for up to 25 years. So we have seen in India, it is 10 years and further renewable up for 5 years, whereas in UK, it is applicable for 25 years and must be renewed every 5 years. So after every 5 years, you can go on registering or renewing. You can see some of the industrial designs which falls under consumer products like iron, bottle, bag, brush, toothbrush, wallet, pen, watch, even chappals, pen holder, fridge design, then flower pot, and many more things are there which falls under consumer products, and we see different designs are there daily. Then there are some industrial designs which comes under pharmaceutical products like syringe, then tablets, then uh, saline bottles or medicine bottles, then dispensers. So all these are having industrial design which comes under pharmaceutical category. Then related to the textile and jewelry, you can see different ornaments, jewels, necklaces, and curtains, diamonds, dress material. So this all comes under textile and jewelry part of industrial design. So these are having different designs. Now, what are the rights of the registered proprietor? So the proprietor of the registered designs has the exclusive right to apply the design to any article in the class in which the design is registered. So one can uh, has exclusive right to apply the design to any article in the class which is design which the design is registered. And again, as earlier discussed, that in India it is protected for 10 years and can be extended up to 5 years after renewing. So these are the rights to the registered proprietor. Then what things are excluded from this industrial design rights? Any mode or principle of construction or anything which is in substance or mere mechanical device. So what are excluded? Like trademark, property mark, artistic work. Now, will these things are also important when we talk about industrial uh, uh, IPRs. Now, what is not registrable? A design which is not new or original. A design which is not a new one or not original. So such designs cannot be registered. A design which has been disclosed to the public anywhere in the world prior to the filing. If you go to the registering one product industry design or design a product, but it is found that already it is disclosed somewhere through some social media or through some conferences or publications, then it cannot be registered. A design which is not significantly distinguishable from known designs or combination of known designs. So if you modify some existing design and try to register, then it is not uh, registered because it should be significantly distinguishable from the existing designs. A design comprises or contains scandalous or obscene matter. If it is having some disreputable or disgraceful disgraceful matters, then such things are also not accepted. Then a design which is contrary to public order or morality, so such things are also not acceptable. Now again, there are some things in day-to-day life which cannot be registered, or you can call it as not registerable articles. For example, we see calendars, certificates of various events, or when we organize some programs, training programs, faculty development programs, student development programs, and we offer certificates with different designs on that. But those designs cannot be registrable under IPR Act. Or we design web forms or filling forms, greeting cards, leaflets. So all these cannot be registered articles. Then maps of a maps of a city or state, then building plan, medals. So these again cannot be registered. Labels, tokens, stamps, then religious symbol designs, mechanical contrivances, building and construction or real estate shapes or designs, then flags, emblems or signs of any country, computer icons, parts of articles not manufactured and sold separately. So these things cannot be registered because these are fixed and this is in general. Layout design of an integrated circuit, basic shape. Like if you're designing some circuit, then layout of that IC cannot be patented or registered. Then variations commonly used in the trade, mere workshop alterations or change in size and shape, or any principle or mode of constructive construction of an article does not fall under registration. So these things we have seen in day-to-day life. So that cannot be patented, that cannot be registered. Now the next point is trademarks. Now we have seen such many uh, examples or ads in day-to-day life on TV or in the newspaper or even when we are crossing something. So you have seen here is one picture of a reputed company having some cold drink with some certain shape, and what you observe there, it is having certain name, or there is some logo type of a particular brand, or a symbol is there, or there is some slogan or statement to catch the consumers, or it is having some typical shape or typical colors are used, and these are all trademarks. And you can see here TM, that is trademarks, or here you see R, that is registered. So those are nothing but trademarks. Now we'll see what are the points considered in trademark. A name of an enterprise or a mark capable of being represented graphically, distinguishing the goods or services of one person from those of others. For example, we see soaps like Lux, Godrej, TVS, Telco, then 555, Apple, and many more such. So these are all comes under trademarks. So a name of an enterprise or a mark capable of being represented, it may be graphically or distinguishing the goods or services from the existings or from the those of the others. So those known as trademarks. Then It can be consist of a sign. It may be having some words, letters, numbers. It may have some drawings, pictures, or some symbol or sign, emblem, colors or combination of colors. It may consist of shape. It may graphic representation or packaging or any combination of the above. Like it may consist of picture and words. It may consist of colors and words, text, or some graphical representation. So it as applied to an article or a product. So again, trademarks are registered by national trademark registries and are valid in that particular country. Now registration is made after examination and publication. So it, if someone applies to the registration of trademark, then it that immediately will not get, it will be examined and then only it will be granted. And again, the period of registration is 10 years and it can be renewed indefinitely afterwards. So initial registration period is 10 years for the trademarks. Now, what kinds of trademarks are existing? So marks on the goods, some marking is there, service marks are there, then certification of trademark or collective marks or well-known marks or trade names. So these are all different kinds of trademarks. Now, what do you mean by these all service mark or collective marks? Service marks includes banking, education, finance, or insurance, or real estate, entertainment, repairs, transport, conveying news and information, advertising, etc. So these are service marks which are providing services. So that's why they falls under service marks, which like banking sector, education, finance related, insurance, real estate, entertainment, transport. Now another one is certification trademarks set. So this is certified by the proprietor as having characteristics like geographical origin, ingredients, quality. For example, egg mark or wool mark. Certification mark cannot be used as a trademark because this wool mark company itself certifies that goods on which it is applied are made up of 100% wool and it is registered in 140 countries and licensed to the companies which assure that they will comply with the strict standards set by the wool mark and the owner of that mark. So this wool mark itself is a company and they certify that whether the product is 100% having wool or whether it meets the strict standards set by that wool mark company. So such marks are known as certification trademark. Then another is collective mark. It is a mark that distinguishes the goods or services of a members of association from marks of other undertakings. Now, who owns this collective mark? So generally association of persons. For example, in manufacturing or any producers, suppliers, traders or other profession bodies like Institute of Chartered Accountants, Test Cricketer Association or governing bodies. So these associations owns this collective mark and they give this collective mark. Then another is well-known marks. So well-known mark falls like Coca-Cola for soft drink or Toblerone, that is triangular shaped chocolates. Trade names like Godrej, refrigerators, Novel, comparator, or even uh, G bulbs. So these examples we have seen. Now, what are the forms of these trademarks? So generally visual, it consists of words, letters, or numerals or device, including drawings and symbols or 2D representations of object or a combination of two or more of these. It may consist of letters, subjects, symbols, text like this. and color combination or color per se, like 3D sign as shape of goods or packaging. So visually, whatever is seen. So such are falls under visual trademarks. Then there are audio trademarks also, which consist of sounds or musical notes. It may consist of sounds and musical notes. So we have seen there is a special tune of Airtel in last decade. So that is a form of audio trademark or olfactory that is related with the smells. So some typical brands have their typical smells. So those falls under olfactory trademarks. Again, in trademark, what which things are protected and which are not. So then right to use TM, that most of the products we see this letter TM in small letters. That is nothing but the trademark in relation to goods or services as registered are protected. So wherever uh, TM is mentioned, it may be related to some products or services are registered and these are protected. If TM consists of several parts, protection is for TM as a whole. So whenever it is registered under TM, then those are all protected. Then what are not protected? State emblems, official hallmarks, emblems of intergovernmental organizations cannot be used as TM. So these are related with the governments or official hallmarks. So such things cannot be used as uh, TM. So trademark infringement and counterfeiting and dilutions. So infringement, a mark that is likely to cause confusion with a trademark already existing in the marketplace. So if a mark is developed or designed such that creates a confusion with existing trademark in the market, then there may be infringement. Counterfeiting, if the deliberate copying of a mark is done, then there may be counterfeiting or dilution. The value of the mark is substantially reduced through the competitor or through the likelihood of confusion from another mark. So these things may create infringement, counterfeiting, or dilution. Offenses include falsifying and falsely applying trademarks. Trade description are punishable by imprisonment and fine. So there may be punishment of imprisonment or there may be monetary fines if someone uh, performs these kind of acts. Now the next is trade secret. So a trade secret consists of a formula or a device or idea, process, pattern or compilation of information that gives the owner a competitive advantage in the marketplace. So it may consist of a formula, device, idea, a novel idea that is not common knowledge and is kept in a confidential state. So these things are trade secret. It is not protected by federal law and can only be protected through employment contracts and or maintaining tight security. So these are trade secrets are protected through employment contracts or maintaining tight security. Then recipes, ingredients, codes, manufacturing costs. So these are all falls under trade secret. Now variants of trade secrets like limited rights in technical data, restricted rights in a computer software, government purpose rights, special license rights, geographical indications. We will discuss this point in the next lecture.